Good afternoon, everyone. We are just waiting for a minute more. Couple of people are still joining our webinar, so let's wait for everyone to be on board, and then we'll start with the webinar. Thanks. I think we should start aligned with our time of 3 p.m. So, warm welcome to everyone viewing our webinar today. Uh, Today is World International Data Privacy Day. So, for this purpose, we've kept this webinar from network intelligence, and that's why this makes it very timely. So, across geographies, organizations are moving from viewing privacy as a policy requirement to treating it as an operational and architectural priority. As GDPR matures, organizations aligning with frameworks such as India's Digital Personal Data Protection Act. We'll discuss how these regulations align, where they differ, and what this means in practice from consent and data transfers to breach response and audit readiness. So, before we begin our webinar, I would request if you can share your questions via the Q&A chat in the Q&A window or the chat window, and our speakers will take up their best ones at towards the end. With that, let's get started with our webinar. So today I have with me, we have Udit Pathak and Vishal Gurule from Network Intelligence. We are pleased to have you on board today. And Udit, let me introduce you. Udit currently serves as AVP Delivery for the US and European markets. He leads large-scale governance, risk, and compliance arrangements for global clients. He brings strong hands-on experience in managing complex regulatory programs, driving risk-led compliance initiatives, and aligning governance frameworks with business outcomes across diverse regulatory environments. And joining him today is Vishal Gurule, who's also uh, the delivery head for India, APAC, and Meta regions. He also leads governance, risk, and compliance delivery engagements across enterprise environments. Vishal brings strong hands-on experience in executing compliance programs, operationalizing risk and control frameworks, and translating requirements into scalable business-aligned solutions across varied regulatory landscapes. A warm welcome to both of you all. The stage is set, so please take over Udit from here. Thank you. Yes, Sudit, over to you.
Oh, sorry, there was some issue with my mic. That's why I think a lot of audience could not hear me. I'll start again. Hey everyone, very good morning, good evening, good afternoon. Thank you for joining the session for GDPR to DPDP. I'll quickly set the context. We are here to understand how do GDPR and DPDP collaborate together. I'll not start with the very basics, such as what is data privacy and why is data privacy important. Rather, we'll try to understand that if you are already compliant with GDPR, then how do you leverage the existing requirements of GDPR and then comply with DPDP requirement. We all know that GDPR has been into the market for almost 6 years now, and the rush for GDPR is highly likely that it is completely over. But now what we see that there is strong regulatory push, such as the privacy is more than only the cookie banner. There are big fines and penalties getting imposed to the organization who are getting non-compliant. And with this DPDP regulations coming in, there would be some implications on organizations which fall into the DPDP compliance requirement, that they will have to comply with GDPR, DPDP, and many more other compliance requirements as well. So in this particular session, we'll try to walk you through with at a very high level what DPDP is, the at a high level the mapping between GDPR and DPDP, and then you as an organization or maybe you as an individual, what is that you can do to make sure that you have a standard framework which helps you comply with both the compliance standards, both the privacy standards, GDPR and DPDP. So I'll let Vishal do talking about the basics of data privacy first. He's gonna talk about the foundation, and then from there we'll start. We'll take the session over. Vishal, whenever you're ready.
Thanks, Udit. So, before we get into actual controls on GDPR and DPDP, let us first understand where these laws come from. What is the foundation? What is the basic foundation all these laws are built upon? So, the answer is common set of principles. These principles existed long before GDPR and India's DPDP Act. They explain why these laws look similar in spirit, even when legal language differs. These are called as generally accepted privacy principles. Now, these principles were developed by AICPA and the Canadian Institute of Chartered Account as globally accepted framework for privacy governance. Uh, think of a GAPP as a DNA of modern privacy laws. GDPR, DPDP, HIPAA, or even upcoming AI and sectoral laws all map back to the same principles. Now, why should experienced professionals care about principles? Now, the first principle help you when the law doesn't give clear answer. Many a time, we face this situation that law is not clear about specific control or specific situation your organization faces. Now, for an example, DPDP is a shorter, less detailed law than GDPR. Then, in this case, you can ask yourself what would be the basic principle. You can rely on basic principle, and that is how you make defensible decision. Second principle, let you build one program for many laws. If you design your privacy program around these principles, then you can extend it to any new law, be it GDPR, DPDP, or whatever comes next. You're not rebuilding each time, you're just adjusting setting. And the third principle, you can use as a defense when regulators ask question. Suppose when regulator finds a gap in your compliance, the weak answer is the law is not clear about this specific situation. Rather than saying this, you can provide a strong answer saying that our privacy program is built on principles and XYZ principle basis on the situation. And if you revert like this, regulators do respect that. And instead of saying law is not clear, this is a smarter way to respond to the regulators. Now let us deep dive into this principle. What are these principles and how these are you'll how you will find these principles in both the laws GDPR and DPDP. Let us start with the first principle, which is management. Now, privacy cannot be owned by IT alone or legal alone. Someone at the top must be accountable. This principle requires clear ownership of privacy, defined policy procedures, ongoing governance and oversight. Now, in simple terms, if something goes wrong, who is responsible? Regulators don't accept shared responsibility as an answer. They expect name accountability. Second principle is this. Now you'll find this principle in both the privacy law. Individuals have right to know what data you collect, what data, why you collect it, how that data will be used, who will that data will be shared with. Now, notices about transparency, not legal complexity. Strong privacy notice is always clear, understandable, written for humans, not for lawyers. If a regulator reads your notice and can't understand it, that's a red flag. Third principle is choice and consent. This is about giving individuals meaningful control over their personal data. Now, consent should be free, it should be informed, it should be specific, it should be easy to withdraw. Importantly, consent is not just a checkbox. Organization must be able to prove it. What the user was told, when the consent was given, for which purpose consent was taken. Weak consent management, weak consent mechanism are one of the top reason for regulatory penalties globally. Fourth principle is collection. Now, just because you can collect the data doesn't mean you should. The principle requires collect only what is necessary, collect data for defined purpose, avoid excessive or speculative data collection. Now, uh, if a regulator asks why you collect this data, can you justify it clearly? If answer to that is yes, then you're good. If answer to that is it might be useful someday, then that's a problem. Next principle is use, retention, and disposal. Now, the data should be used only for the stated purpose, retained only as long as necessary, and securely deleted when no longer required. Um, all these principles are somehow common in both GDPR and DPDP. If you have gone through the laws, then you'll find similarities around all these principles. Both GDPR and DPDP talks about this. Next one is access. Individual should have right to know what data you hold about them. Now, GDPR also talks about this. DPDP also talks about this. So, what exactly access means? Access means user what data exists, how it is used, who it has been shared with. Organization must be able to locate data quickly, verify identity securely, respond within defined timelines. If you cannot find someone's data, that's usually indicates poor data governance. The seventh principle is disclosure to third parties. Now, while sharing data does not mean you shared the responsibility. Again, this principle requires you to do a due diligence of vendors, strong contractual safeguards, ongoing oversights of process. and partners. Regulator consistently hold organization accountable for vendor failures. Our vendor caused a breach is never acceptable defense. Now, if you look at the GDPR requirement, that has different requirement, and in DPDP there are different requirement, but then principle is common. While you share the data with third parties, you should have controls around it. The eighth principle is security. Privacy without security does not exist. Organization must implement technical controls like encryption, access management, organizational controls like policies, trainings, logging, monitoring, incident response. All these security controls are included in both TPDP and GDPR. The ninth principle is quality. Uh, a personal data should be accurate, complete, up to date. Again, both the privacy law talks about qualities. There are different requirements from both the privacy laws. And the last one is monitoring and enforcement. Privacy is not a one-time project. Organization must have monitoring compliance. Organization must conduct audit and assessment, track incidents and complaints, and continuously improve controls. So if you again refer to the laws, you will find similar requirements in GDPR and DPDP also. Those are not identical requirement, but then principle is monitoring and enforcement, which is used in both the laws. Next slide. Udit, can you change the slide? Yeah. So this is a mapping of a principle with GDPR and DPDP. As I said before, if you read the law, if you go control wise, you will find all this principle in both the laws. Legal requirements are different, but baseline is same. 10 GAPP principles. Over to you, Udit, for. Am I audible?
Thanks, Vishal. Well, Vishal, that was beautiful insight based on my experience dealing with different data privacy laws, say GDPR, HIPAA, CCPA. Since I mainly focus on US and Europe region, what I've understood that most all of these data privacy laws are largely the same. What varies is the threshold, enforcement, timelines, the breach response, and the penalties. If I have a look at any of the data privacy law, there are a couple of things which are always common. For an example, every data privacy law would try to protect the personally identifiable information. In some cases, the personally identifiable information which are protected are largely related to health-related information, say for HIPAA. In some cases, it is for minors or children, say Children Online Privacy Protection Act. In some cases, it is the information in a particular form, say in digital form only, like in DPDP, I believe it is only for the information which is held by an organization in digital format. And in some cases, it is the overall personally identifiable information, be it in any form. What I also learned from my study of different privacy laws, that it provides rights to everyone. So every data privacy law would have rights for sure. In all of the data privacy laws, again, one common thing that I've seen that all of those would have a policy for sure, which is privacy policy. In some cases, it is referred as notice of privacy practices. In some cases, it is referred as privacy policy. In some cases, policy itself. And the other thing that I've understood very common in different data privacy laws, that each of the data privacy law would ask you to have a breach response process for sure. And every breach may result into a penalty as well. So that was one good insight, Vishal, that if we learn about the generally accepted privacy principle, your journey for implementation and understanding of data privacy becomes much more easy. So thanks for sharing this good insights, Vishal. Now I'll move to the next one. Let me know if my screen is visible. I believe that there is a little bit of network glitch that we are experiencing today, and that's the reason some part of the session is getting deteriorated. Now let's try and understand the applicability of GDPR and DPDP. For GDPR, I think the applicability is pretty much clear. If your individual for which the personally identifiable information is getting collected, if the individual is located within European Union, then of course GDPR applies. If you as an organization is established within European Union, then GDPR shall be applicable. Say if you are not in European Union, but you are performing behavior-based monitoring within European Union, then GDPR shall be applicable. Well, GDPR applies to any form of the information, be it digital or in a physical format. It applies in general to personally identifiable information which is collected. But when we talk about DPDP, what I understood that it applies only to the digital information, something which is available into the electronic format. There is no separate clause that talks about if you perform monitoring within India, then DPDP would be applicable or not. So the law is silent on this, but I believe as long as you are dealing with the personally identifiable information within India, then then DPDP shall be applicable. Now, you may have a question that can I comply with GDPR and DPDP both? Well, answer to that is yes, you can do it together. If you always have a question that how do I identify which particular data privacy law apply to me? So there is one quick tip that you can remember, that if you serve for both US and Indian markets, then both the laws shall be applicable to you. What is more important for you to understand is not to identify which particular law is applicable, but it is more important that for you to understand that how do you comply with both the data privacy laws efficiently and effectively. So here is a quick flow chart if you have to figure out how does GDPR applicability work. So if you are an enterprise within European Union, since it is law of the land, GDPR shall be applicable. But if you say that you are not an enterprise within European Union, but the data subjects, as in the individuals for which the personally identifiable information is being collected, if the individual is in European Union, if answer to that is no, and that individual is not going to be in European Union even for the temporary period, then in that case GDPR shall not be applicable. But if the individual is there even for the temporary period of time, and you are offering goods and other services, or if you are performing the behavior-based monitoring, then in both the cases GDPR shall be applicable. For DPDP, it's very simple. If you are within India, then DPDP shall be applicable. If you are dealing with if you are an established organization within India, then DPDP shall be applicable to you. Now let's try and understand what are the key terms which are similar or dissimilar within GDPR and DPDP. Personal data, GDPR says personally identifiable information as personal data. It could be sensitive in nature, it could be personally identifiable information in nature. DPDP try to protect the digital personally identifiable information or digital personal data. So important to understand that DPDP shall only cover the personally identifiable information available only in the digital format. The individuals for which the personally identifiable information is collected is referred as data subject in GDPR, while it is referred as data principal within DPDP. In case of a minor, it's going to be the guardians who will be taking the consent or maybe signing on the consent in GDPR as well as in DPDP. The data controller is referred as data fiduciary. Data controller is an organization that would collect the personally identifiable information or would identify the lawful basis against which the PII can be collected or processed. So the data controller, the analogous term in DPDP is data fiduciary. The processor and the data which is referred as data processor within DPDP, they are the organization who would process the personally identifiable information on behalf of data controller. If I'm correct, then in GDPR we have obligation for both the data controller and data processor to do privacy and the security well. But in DPDP, it is the responsibility of data fiduciary to ensure that the processors are getting compliant. So, say in the event of a breach, your processor shall not be penalized for the breaches by the legal authorities, but it's going to be the data fiduciary. So, it is expected that you would have strong contractual obligation or maybe clauses written so that the responsibilities of the data processor also gets covered. Okay, let me quickly check. Okay, let me quickly check if there are questions. Okay, the webinar. Okay, a webinar is getting recorded, so that shall be available on demand at a later stage as well. Question from Carlos. I have answered this. Okay. Now, the DPOs, the term DPO remains same in both the data privacy laws. Only case is in GDPR, the requirements of DPO is clearly mentioned, as in if you are a legal, if you are a public entity or a government entity, you are supposed to have a DPO for sure. And if you are an organization that processes large volume of the data, or if you are an organization that handles the special category of the data, then you may have to appoint a DPO within the organization. That becomes an obligation. While in DPDP, the DPOs are only required for an organization that is classified as significant data fiduciaries. Now, what is a significant data fiduciary? Well, there is no definition provided by DPDP as such, and that's where your generally accepted privacy principle comes in picture, wherein there are no clear definition. You can correlate this with the generally accepted privacy principle and figure out what the organization, what that particular legal requirement says. However, as per DPDP, an organization can be designated based on the volume of the data. Again, what volume is not defined. Is it like 10,000 records, 50,000 records? That's not defined. Sensitivity, risk of rights, national security, risk to democracy. Based on that, government can designate you as an organization as significant data fiduciaries. So the clear definition does not exist. Rather, it would be defined by the government. As in, this requirement is open-ended for now, but an organization can be identified as a significant data fiduciary by the government system. Now, in terms of enforcement, the GDPR enforcement is done by the supervisory authorities. There are 27 supervisory authorities or Information Commissioner's Office (ICOs) within European Union. While in India, for DPDP, it's going to be Data Protection Board, which is a single board for entire country. That's the key terms and the rules within DPDP. Now let's try and understand the legal which processing of personally identifiable information can be done. In GDPR, there are 6 legal grounds on which the processing of personally identifiable information can be done. The first one is consent, wherein you provide consent when you get a consent from an individual. That means you can go ahead and start processing the personally identifiable information on my way. Second, when the processing of the personal information is necessary to execute a contract. For an example, you are someone who is planning to buy an insurance policy. That means you would get into contact with the insurance service provider. Now, in order to execute that contract, we provide you with a policy with the exact amount that needs to be paid by you. The insurance agency may have to process some of the personally identifiable information. So then that's an example of getting into contract. When there is a legal obligation, when the government or maybe the regulator mandates you to process personally identifiable information. For example, verification of Aadhaar details within India, verification of primary the permanent account of a bank within India. So those could be some of the examples of legal obligation. At times, it is important to process personally identifiable information for vital interest as well. That means to save someone's life. Now, say, imagine there is a hospital wherein there's a patient who's suffering from a very critical disease, and the doctors are supposed to operate the individual. Now, in those cases, without the consent, without now, it is since it is important to save someone's life, doctors would have an authority to get access to the personally identifiable information of the individual, maybe get into the health records of the individual and process that information so as to uh, uh, to provide to preserve the vital interest of an individual. At times, it is also required for the public interest, as in like for the public safety. For an example, agencies performing large-scale CCTV monitoring. Now, this is often required for public interest, or it is required for public safety. The last one, which is tricky, which is mostly uh, an organization's call, which is called as legitimate interest. So, in legitimate interest, the organizations can decide uh, for which particular purpose they would want to process the personally identifiable information. For an example, direct B2B marketing, maybe for fraud detection, maybe for customer risk analysis, or maybe to perform security monitoring for the individuals. Now, for this particular thing under GDPR, the organization has no obligation to take the prior consent from an individual, but just to safeguard or just to preserve or maybe just for the legitimate interest for an organization, the organization can go ahead and start processing the personally identifiable information. Vishal, why don't you go ahead and share your views on the legal grounds against which the personally identifiable information can be processed within DPDP?
Under DPDPA, organization can process digital personal data only on two grounds. First is consent, and second one is legitimate use. Now, when we say legitimate use, it is listed in a law itself, like when there's a legal requirement to disclose the data for government functions, government providing subsidies, uh, court orders or legal claims, medical emergencies, like as you said, threat to life or immediate health. Uh, these cases are specifically listed. These are not flexible like GDPR. Some of the other use cases listed are disaster or maintaining public order, employment like HR purposes, or protecting trade secret. These are specifically listed under DPDPA. It is not flexible like GDPR.
Thanks, Vishal. That was some good insight. Now let's try and understand the consent rule under GDPR and DPDP. So both the data privacy laws, GDPR under Article 7 and DPDP under Rule 4 of Section 6, talks about how the consent should be given. So there is a lot of similarities that we have observed. In both the data privacy laws, it is mandatory that the consent should be freely given. It should be specific, informed, and it should not be ambiguous. And it is also expected that you write consent in a clear, simple language, and it should not be a cryptic legal language in which you ask for the consent from an individual. There is one difference in terms of the proof. In GDPR, it is must that the controller prove the consent, that the consent was given. But in DPDP, you must prove that the consent was given, followed by the privacy notice, and you must be able to establish a connection between these two. Withdrawal in both the cases, the consent can be easily withdrawable. In DPDP, there is another aspect which is added, that you must have a consent manager who can manage consent on behalf of an organization. Now, there are certain specific requirements. Shall do you want to throw some light on those specific requirements for the consent manager?
Am I audible? Yeah. Sorry, there was some issue with the laptop. Yes, this is something new in DPDP. Now, as per DPDP, consent manager is a registered entity that acts as a single point of interaction for individuals as well as data principals. Think of this like a consent wallet. Now, if organization wants to be a consent manager, there are certain requirements which organization has to meet. First requirement is organization must be incorporated in India. It must meet financial and technical capacity threshold. There is a requirement of minimum net worth of 2 crores, and there is a requirement of uh, entity to undergo certification and registration process. Now, consent manager must be interoperable, meaning it should work across multiple data fiduciaries. These are the specific requirements listed under DPDP consent managers.
Well, that's a new requirement. I think if you're an organization who will try to comply with the DPDP requirement, that should be one of your focus, because that's a new concept. You will have to maybe engage with a consent manager to fulfill your data privacy consent requirement. That was a good insight, Vishal. Thanks. And now let's try and understand the notice requirement. Notice is generally also referred as a privacy policy. In both the data privacy laws, there is a requirement that you must have privacy notices in place. While in case of GDPR, the requirement is more strict. There are about 13 items or line items that you must include as part of your privacy notice. For an example, uh, who you are and how to contact you, maybe the contact details of the organization. If DPO is applicable to your business, then you must have the contact details about the DPO as well. You should also tell very clearly that why are you collecting the personally identifiable information? What is your legal basis around this? And what if at all are you processing the personally identifiable information for a legitimate interest? Then what are your biases around it? You should also clearly mention that who are the third parties who will be receiving or who will be receiving the data. You should also clearly mention if you are transferring the personally identifiable information outside the European Union, and what are the safeguards that you have implemented. The data retention requirement has to be written very clearly, provide the details around the rights which are given to individuals. Clearly mention that the individuals have got rights to withdraw the consent as well. And if you deny that, then what are your logic or what is your bias around it? You should also provide the contact details about the respective ICOs wherein an individual can go ahead and do a complaint if at all they feel that their data privacy rights are violated or not respected. There are furthermore requirements around the notice in GDPR, which is if there is an automated decision making that should happen, then how it works, and then provide rights to individuals so that they can deny the automated decision making. While it comes to DPDP, the requirement is simple. There are only 4 items that you need to include as part of the data privacy policy or the privacy notice, which includes what data is getting collected, for what is the purpose, how can I exercise my rights, and how do I do complaint. So it is very noticeable that in GDPR, the notice requirements are more stringent and those are more strong. So if you are already complying with the GDPR requirements for notice, you are largely complying with the DPDP notice requirement as well. In data description, you have to clearly mention the categories which are uh, for each of the category for which you are collecting the personally identifiable information. But in case of DPDP, it must be itemized. You will have to specify every personally identifiable information that you should be collecting. How the notice shall be communicated is different in both the cases. In GDPR, there could be a short summary followed by a link wherein one can click and then get access to the notice. While in case of DPDP, It would not work that way. You'll have to provide a clear, understandable, independently notice. So there would be a big pop-up which would have the entire notice printed, and then one has to go click it and accept it. In terms of languages in GDPR, the notice is fine as long as you are providing it as part of the member state languages. But in DPDP, it has to be English plus any of the 22 languages listed as part of the law. So these are some of the requirements around the privacy policy or the notices in GDPR and DPDP. Now, let's try and understand how do this data privacy laws try to protect the rights of children or the minors. In GDPR, the age threshold starts from 13 years, while it can vary from 13 to 16 depending on the various member countries. So every member country may have different age group for which they consider an individual as a child or minor. But in DPDP, it is fixed. It is 18 years. There is no flexibility. Um, when you now the question comes that is it mandatory that I figure out that an individual has got is a minor and belongs to a particular age group? Well, answer to that is yes for DPDP. You must have a verifiable method to identify if the individual is child or minor or not. In case of GDPR, you must have reasonable efforts. There is no obligation that you go ahead and verify this. But in case of DPDP, there are obligation that you go ahead and verify this. In GDPR, the behavior-based monitoring or targeted advertising for a child is not banned, while in DPDP it is not allowed. Well, these are some of the key similarities and dissimilarities while protecting the rights or the kind of rights which are given to children in GDPR and DPDP. Now, these are some of the individual rights. Vishal has already spoken in brief about all of this, so I'll maybe skip this one. But if you want to make a note of the different articles, maybe we'll share across the slide deck with all of you. You can have a look at this. Now, let's try and understand the security and the breach responses within GDPR and DPDP. So, in GDPR, you must have appropriate measures in place, as in you would perform a risk-based assessment, and then you would decide what kind of security controls that you implement. While in DPDP, those are outlined. You must have at least 6 controls implemented. Now, this is at least 6. Doesn't mean that if you implement 6 of these controls, and you are complying with the DPDP requirement. So the 6 controls are that you must have log retention period. That means you retain all of your security logs for at least 1 year of time. You must have processor contracts. You must have access control in place. Now, it says you must have access control in place. It doesn't say that go ahead and implement multi-factor authentication. So this is something that would get derived based on the risk-based assessment that you would want to perform for your organization. It says that implement data security controls, say encryption, obfuscation, masking, tokenization, whatever is applicable to your organization. In the event of a breach, GDPR says that respond in 72 hours, unless, or in case of DPDP, you have 72 hours. In both the cases, the timelines can be extended by the respective governing bodies. So these are some of the guidance differences, similarities in GDPR and DPDP for security and the breach responses. For international transfer in GDPR, by default, it is blocked. You can only transfer the personally identifiable information outside European Union if there exists an adequacy citizen, or if there are safeguards in place, or if there are standard contractual clauses or binding corporate rules in place. But in DPDP, it is allowed, as in like it is allowed by default. You can transfer the personally identifiable information outside the country as long as there are safeguards in place. But DPDP adopts blacklist approach. That means at any given point in time, the government can say that certain countries, certain areas are restricted, and you cannot transfer the personally identifiable information to those countries. Right now, at this point in time, there are no countries which are blacklisted. Vishal, do you want to talk about the penalties and the enforcement for the GDPR and DPDP?
Sure thing, Udit. Um, let's close this comparison with the penalties and enforcement, because this is where the risk profile under GDPR and DPDP looks very different. Under GDPR, enforcement is decentralized. There are 27 plus data protection authorities across Europe operating under a lead authority model. Um, in GDPR, penalties are revenue linked. Um, it is up to 20 million or 4% of global annual turnover, whichever is higher. For large organization, this can translate into very significant fines. Now, in GDPR, it also allows private lawsuits by individual and consumer group actions. So organization face regulatory penalties plus litigation risk as well. Now, in DPTP, the approach is different. India will have one central authority, the Data Protection Board of India for entire country. Uh, Penalties under DPTP are fixed caps, not linked to revenue as such. The maximum penalty is 250 CR, roughly around 27 million. Importantly, there are no private lawsuits, no consumer group action. All enforcement happens through the board only. Uh, Looking at the penalty schedule, security breaches can attract penalties up to 250 CR. Failure to notify a breach is again 200 CR. Children's data violation is also a 200 CR. Significant data fiduciary obligation is up to 150 CR, and other violations are also up to 150 CR. There's one more category here, data principal duly violation. It's up to 10,000 rupees per violation. So these are the penalties involved in GDPR and DPDP in case of non-compliance.
Thanks, Vishal. Now let's jump towards the last session, wherein we try to understand how is it we can build a program which would help you comply with the global data privacy requirements. So, well, if you want to build one program that would work for both the laws, then you have to follow certain principles. For an example, now these are principles that I suggest. I don't say that that's an outcome for a standard, but this is something that has helped me over a period of time when I try to implement different data privacy law for an organization who's to comply with multiple data privacy laws. Now, so based on my experience, if you are an organization, there are one or many data privacy laws that could be applicable to you. One based on the kind of personally identifiable information that you are processing. For an example, if you are processing the personally identifiable information of European residents, then GDPR shall be applicable to you. While you're performing this particular activity, say while you're processing the personally identifiable information of the individuals of European Union, and your physical location, say it's in Philippines, then maybe the data privacy law of Philippines shall be applicable to you as well, because that is the law of the land. At times, it is the nature of the information as well. Say if you are processing the protected health information within United States, then maybe HIPAA would be applicable to you. So it is highly likely that based on the geographical location, the kind of personally identifiable information that you are processing, there could be one or many data privacy laws that could be applicable to you. Now, one simple way to address this particular situation is that you follow this three simple principles. One, that you start building the standard with the highest the privacy law that would define the highest level of controls. So for an example, you would see in the slide that we have a higher standard and the specific area. So for an example, capturing the consent, DPDP has got higher standard. Providing the notice, GDPR has got harassed. I mentioned that there are 13 plus items that you have to capture as part of GDPR notice, while it is 4 or 6 in PDPA. Uh, Transfer mechanism GDPR says that it is more stringent. You cannot transfer the personally identifiable information unless you have binding corporate rule or standard contractual clauses, or you have adequacy decision in place. While in case of DPDP, it is allowed, but with some restrictions that may appear in future. So it is always important that we start with one particular law which is stricter and then use that as a standard, and that would always satisfy the other law which has set the standard relatively low. You should always configure it. You should not go ahead and duplicate the the standard. For an example, having two different data privacy policy within the organization would not make any sense. So you should not duplicate the programs. Rather, you should build one particular program and configure it in a way that it would satisfy the judicial requirement for different geographies that you're trying to cater to. And then you should build it on a principle, as Vishal explained, that there are 10 generally accepted privacy principles. If you adopt that approach, then you'll be able to prepare a data privacy strategy within the organization that would be suitable for different data privacy laws and different geographies. So here is the practical control mapping between GDPR and DPDP, which says that which particular standard provides higher level of, which particular law provides a higher level standards, and which standard provides relatively lower level of the controls. So now the question comes that what do we do and when do we do it? So GDPR, I believe, if you're an organization, you should be already compliant because that has been there into the system or in the market for almost 6+ years now. For DPDP, you can still go ahead and create the timelines. I would say that you start the assessment. Timelines could be 1 to 4 weeks depending on the size of the organization. First and foremost thing would be to identify the inventory of the data. Now, can I perform the data inventory analysis manually? Well, that is doable, but practically impossible. Because if you are a large organization, figuring out which particular person identifiable information have you stored, in what format is stored, with whom you are sharing, it becomes very difficult. So in those cases, having a data discovery tool, data identification tool, data mapping tool helps. One of the quick win could be, now once the data is identified, maybe you can start implementing the control. You can perform a gap assessment and then start bringing the control. The second, one of the quick wins could be that you start sending the retrospective notices, because in DPDP, if you have collected personally identifiable information before DPDP come into the enforcement, you are supposed to send notices to individual for which the personally identifiable information was collected. And if you don't get the consent, then you'll have to stop processing the personally identifiable information. You will have to focus more on the technical safeguard. For an example, age verification system for the children, consent manager integration, breach notification workflow. So these are some of the technical controls for which either you have to develop a technology or bring in some controls within the organization. So that may take some time, but then you'll have to do some budgeting exercise for that as well. And then setting up a governance framework. Say you as an organization is classified as a SDF, or if you as an organization are required to perform data protection impact assessment. So in those cases, maybe you should set up a governance framework within the organization so that you keep on monitoring the SDF notification, you keep on performing the data privacy impact assessment, and take the corrective actions as and when required. So here are some of the key compliance timeline. November 2025 was the time when broad procedures came into an effect. November 2026, the consent manager rule would come into an effect. And by May 2027, you will have to become a fully compliant entity. So there are a few things that you must remember. DPDP is live. It's not a case that it's going to happen in future. It's already live. Both the laws, data privacy laws, GDPR and DPDP, they have almost 80% of the similarities. So you should go ahead and build one program based on the principles. Legitimate interest is a real gap. If you're already compliant for GDPR requirement, then legitimate interest could be a gap. So you should focus more on that. Children data is heavily restricted. 18 years is a threshold, and you should have verifiable consent. You cannot track it. You cannot do targeted advertisement, and you cannot also perform the behavior-based monitoring. So if you are someone who's doing this, maybe you should talk to a legal counsel and then understand what should be a way around. And yeah, get started now before it is too late. So that would be all for the session today. Now we are up for the Q&As. Let me see if there are any questions. Vishal and I will try to answer the questions that you may have posted. Vishal, do we have a question that we have to answer?
None as of now. I've answered a couple of them.
All right. So we are towards the end of the session. Yeah, I'll leave it to the moderators.
Hi, it was a wonderful session. So we have 2-3 questions which I would like to ask. So if I may, let me go with the first question. Yeah. So Data Privacy Day has been around for years. So what is the fundamental shift for organizations from the last few years to 2026? What do we expect from the urgency today?
Well, that's well, while the World Data Privacy Day has been there for quite some time, but the data privacy awareness has been into the market for almost 6 to 8 years now. When still remember when GDPR came into picture, that was an eye opener for almost all the cybersecurity and privacy practitioners, and some of the cybersecurity practitioners, to be very honest, understood that cybersecurity and the data privacy are one and the same thing. And in past, it was more of a pen and paper and policy related work that organizations to do. But now with AI, cloud coming into picture, it is shifting towards more of a tool based approach rather than a people and policy governed approach. So of course, people, processes, policies will be there for sure, but then those shall be delivered by the tools, the agentic approach. So the shift that I see with the AI adoption and migration to cloud, that more and more privacy-related violations, something that will encounter, and then more and more privacy-related controls with the help of the next generation tool is something that we'll have to go ahead and implement.
Okay. And there's one more question. Any specific data retention period mentioned in DPDP Act, or it needs to be decided by the organization?
For logs, it is 1 year for data retention, and I think for consent manager, there's a retention period of 7 years, if I'm not wrong with it. Can you please confirm on this? I believe it is 7 years for consent manager.
Sure. Okay.
For consent manager, it is 7 years. For security logs, it is 1 year. But in both the cases, say for an example, in India, RBI has a requirement that should keep the records for at least 10 years of time. So whatever timeline that we see is the minimum timeline. 7 years is the minimum timeline. So if your regulatory requirement says that you should have it more than that, then you are supposed to have it more than that. Same holds true for the audit logs. If your regulatory and the compliance requirement says that it should be more than 1 year, then you should have it more than 1 year. 1 year is the minimum timeline for security logs, and 7 year is the minimum timeline for the consent.
Okay. Okay, thanks. There's one last question which I would like to take up from the Q&A here. Is from an execution perspective, where do GDPR and DPDP differ the most for enterprises, or should we comply to both?
Well, if you have a legal obligation to comply with both, then you have to comply with both. We understood that there are similarities and dissimilarities in both the data privacy laws. But what important point to understand that these data privacy laws do not conflict each other. For an example, GDPR does not say that do not have privacy policy, and it's not a case that DPDP says that have a privacy policy, um, which is in physical format, right? So, and in either cases, they are not conflicting each other; rather, they are complementing each other.
Understood.
So, you should understand the legal obligation and the applicability of this particular data privacy laws within your organization, and then based on the privacy principles or the privacy framework that you adopted, you should go ahead with a unified privacy framework or a common privacy framework within the organization. Well, there was one good question that I could read from the chat. It says that what is the ideal timeline for implementing GDPR, DPDP, and BDP? I have said that now because it could not be never a futuristic timeline, because GDPR has been there for 6 years, DPDP is into enforcement, and I believe PDPL is also into the enforcement. So if you haven't done it, you should do it now.
Yes, and then there's one more just now that has been posted. Will DPDP, PDPL be an IT-led project or an HR-led project?
That's a business-led project within the organization. You all come into the purview of it. It's not the HR who's gonna solve it for you, and it's not the IT alone who's gonna solve it for you. So it's an organization's project, business-related project. You cannot simply put it on your CISOs, or you cannot put it on your CIOs or the IT help desk team. It's for the entire organization. It's a business issue rather than IT issue.
Okay, so I think with that, we will close this webinar today. Thank you to both the speakers for doing this wonderful, insightful session, and to all our attendees. Please note that this webinar will be available on demand on our Network Intelligence official YouTube page. So I would like to say that everyone, please note that we have put our contact details in the Q&A in the chat, so you can reach out to us anytime for your business needs. Thank you and have a great day. Bye-bye.
Thanks. Bye-bye.
Thank you. Bye.